Donald Cupchek, a father, coach, and former police officer, was sentenced in Medina County, Ohio, to a combined prison term after a jury convicted him of abduction and ethnic intimidation against a victim he claimed he believed he was justified in confronting. When Cupchek asked to address the judge one final time after sentencing, the judge's two-word response, "No," closed the door on a case where his attorney later revealed no justification instruction or expert report had ever been submitted at trial.
Your oral motion is denied. Your client has filed motions with this court in which he has indicated that he would prefer to be in prison rather than remain in the Medina County Jail. And so I am going to grant him his wish and let him go to prison at this time.
May I be heard on that, Your Honor?
No.
Okay, thank you.
May I be heard on that, Your Honor? No. 2 words from a judge who had already read the letters, already heard the testimony, and had nothing left to say to a convicted police officer asking for one more chance to speak. Minutes earlier, that same officer had asked to be sent straight to prison rather than wait in the county jail. The judge granted it, not as a courtesy, as a closing door. By the end of this video, you will understand exactly how a justification defense fails at trial and why a defendant's own testimony can become the prosecution's strongest evidence. This sentencing hearing took place in Medina County, Ohio, case number 25-0520, State of Ohio versus Donald Cupchek.
We are here on the matter of State of Ohio versus Donald Cupchek, case number 25-CR-0520. Mr. Cupchek is present in court with his counsel, Attorney Spellacy. We're here today to impose sentence pursuant to a jury verdict which was adopted by the court of guilty of 2 counts of abduction, each felonies of the 3rd degree, 1 count of ethnic intimidation, a felony of the 5th degree, and 1 count of assault, a misdemeanor of the 1st degree.
A jury convicted Cupchek of 2 counts of abduction, each a felony of the 3rd degree, 1 count of ethnic intimidation, a felony of the 5th degree, and 1 count of assault, a misdemeanor of the 1st degree. Assistant Prosecuting Attorney Salisbury represented the state. Cupchek was represented by Attorney Spellacy alongside Attorney Lewis Grew. The presiding judge's name is not stated in the available record.
Mr. Salisbury, Judge.
Both, Judge.
All right. Attorney McNamara and Attorney Salisbury. Mr. Salisbury, are you speaking on behalf of the state?
Yes, Your Honor.
Okay. Do you have any recommendations?
Yes, Your Honor. You heard the trial, so there's no need to belabor the facts. As I said in the Mr. Lajek sentencing, this is a crime that kind of divided the community, very impactful, we believe. We believe the jury.
Donald Cupchek was, by every account presented to the court that day, an ordinary man living an ordinary life before this case. His own defense attorney told the judge directly, he's a father, he's a good father, he was a coach, he was a police officer. Character letters filed with the court described a man his community recognized and trusted. None of that changed what a Medina County jury found him guilty of doing to another human being. By the time of sentencing, Cupchek had already spent 82 days in the Medina County Jail, a stretch his own attorney described as not easy, awaiting a sentence that would determine whether those days were the beginning of a much longer term or the whole of his punishment. The prosecution's position at sentencing rested on what the jury had already decided. Salisbury told the court the jury did not take long to deliberate, a detail prosecutors often use to signal that the evidence left little room for doubt.
And quite frankly, as the court shall recall, didn't take a very long time to deliberate even. The impact on the victim was great, and although that impact was so great, he still to this day is saying he doesn't want anything bad, see anything bad happen to these 2 guys, which is kind of amazing to me, considering what he was put through that day.
He described the case as one that divided the community, and he emphasized something that struck even him as remarkable. Despite what the victim endured, both physically and mentally, The victim had told prosecutors he did not want to see anything bad happen to the two men involved in the case. Salisbury argued that Cupchek, despite testifying and despite never outright denying his actions, had still not fully accepted responsibility. He pointed specifically to the gap between what Cupchek admitted on the stand and what the evidence at trial had actually shown regarding the physical aspects of the assault. Salisbury's central argument was direct Cupchek believed he was justified in his actions that day, and the jury, representing the citizens of Medina County, had already rejected that belief as legally insufficient. This was, in the prosecution's words, a clear case of ethnic intimidation, and the state asked the court to impose a prison sentence, leaving the specific length to the judge's discretion.
Taking responsibility, although he does say he does never deny doing anything. I don't believe that's true. You'll recall his testimony. I don't believe he did admit to all the physical aspects that he did to the victim, but you know, I'm not saying he sat there and denied doing anything. He didn't. And again, he thought he was justified in doing so. That belief was clearly wrong, and it was clearly found by the citizens of Medina County not to be tolerated. Judge, this was a clear case of ethnic intimidation. We believe a prison sentence is appropriate, and we would leave that length of which in the court's discretion.
Most people listening to this sentencing missed what Attorney Spellacy said next, almost as an aside, buried in the middle of his argument for leniency. There wasn't a justification instruction, and there wasn't an expert report submitted at trial. He called it spilled milk, something for a different day. But that single sentence, delivered almost in passing, was not a minor procedural footnote. It was a preview of an appeal.
Discretion.
Thank you. Mr. Spellacy?
Thank you, Judge. Also with me is Lewis Group, Your Honor, and Ms. Hanson is also sitting back there. Judge, obviously I filed a sentencing memorandum with you on June 9th. I believe I'm confident the court got it, read it. There's some great letters attached. I think they describe Don very accurately and very well. You know, this is a tragic situation, obviously, for everybody. And I would disagree with Mr. Salisbury that my client he testified to what he did. We can go over the spilt milk, so to speak, but there wasn't a justification instruction, there wasn't an expert report that was submitted, but that's for a different day, Judge. But I think that could have changed the outcome substantially. Judge, I could just say that in the brief, you know, he's a father. He's a good father. He was a coach. He was a good coach. He was a police officer. He was a good police officer. And I think a lot of these people behind me would support those contentions, Judge. He's been in jail 82 days. They have not been an easy 82. I think the pre-sentence report indicates his likelihood of recidivism is at a score of 1. So I don't think that we need to protect the public from him. And I think the odds of this happening again are extremely unlikely. Judge, I think all those things speak to
A justification instruction is a specific direction a judge gives to a jury, telling them that if they find certain facts to be true, the law permits them to consider whether the defendant's actions were legally justified, such as in self-defense or defense of another person. Under Ohio law, a defendant is entitled to a justification instruction only when the evidence presented at trial, viewed in the light most favorable to the defendant, reasonably supports that theory. Plain English, a defendant does not get to argue self-defense to the jury unless the judge first decides the evidence could support it. If that instruction was requested and denied or never properly raised, the question of whether the jury was ever given the legal tools to consider Cupchek's stated belief that he was justified becomes a live appellate issue. That is the legal question hanging over everything that followed at this hearing. The defense built its argument for leniency around who Cupchek was outside of this incident. Attorney Spellacy reminded the judge of the sentencing memorandum filed weeks earlier, the character letters attached to it, and the portrait those letters painted: a good father, a respected coach, a former police officer with community ties. He cited the pre-sentence investigation report's recidivism score of 1, the lowest possible measure of likelihood to re-offend, and argued that a community control sanction, meaning supervised probation rather than prison, was the appropriate outcome given that low risk. Then Cupchek addressed the court directly. He told the judge he never denied anything, that he took the stand and was honest because his attorneys and his union had told him to be honest. He said he never imagined finding himself in front of a judge in this position, and that the letters submitted on his behalf reflected who he truly was.
Yeah, and I just want to go off exactly what my lawyer just said, that I never denied anything. I took the stand and I was as honest, and that's what I was told to be. I was told to be honest by my lawyers and my union, and that's what I did. I sat there and I was honest, and never in my life did I ever think that I would be here sitting in front of a judge like this. And that's not the type of person that I am, and those letters and everything that are put in front show that what I've done in my life and what I've would continue to do when I'm out. And on behalf of my lawyers and everything, they,
The judge's response became the moment that defined this hearing. The court told Cupchek plainly, "The letters of support do not discuss the effect of your behavior on the victim. My focus is not on whether you are a good person. I am sure you are a fine person. My focus is on your behavior and the impact that had on the victim."
I was advised to keep this as, to basically that.
Well, Mr. Cupchek, I have read the sentencing memoranda. I have read all the letters in support. The thing that the letters in support don't discuss is the effect of your behavior on the victim in this matter. And so my focus is not on whether you're a good person, I'm sure you're a fine person, but on your behavior and the impact that that had on the victim. And so after considering
That single distinction between character and conduct is what the entire sentencing decision turned on. Here is what that distinction means in the real world. Ohio Revised Code 2929-11 requires a sentencing court to weigh the seriousness of the offense and the need to protect the public, but a low recidivism score and strong character evidence do not erase the documented impact on a victim. A judge can believe every word in every letter and still conclude that the harm done outweighs the argument for leniency. That is precisely what happened here. What should have happened differently traces back to trial, not sentencing. If the evidence supported a justification defense, Ohio Criminal Rule 30 and related case law required defense counsel to request that instruction on the record and object if it was denied, preserving the issue for appeal.
Just for the record, count 1 and 2 would merge. I know it's a concurrent sentence, but I believe they would.
I don't want to concede that point, Judge. I don't think they do merge. I think they're separate animus. I think he removed the victim and also restrained him at 2 separate times. So I don't want to concede that they merge.
So, Mr. Spelcy, I have not been briefed on that issue, so at this point in time, I do not believe that they merge, but that perhaps is an issue for appeal.
Okay.
If an expert report on the nature of the confrontation could have supported that defense, it needed to be commissioned and submitted before trial concluded, not referenced afterward as something for a different day. The defense's own admission that an expert report was never submitted is the kind of preparation gap that costs defendants real consequences. In this case, the difference between the community control sanction the defense requested and the prison term the court imposed. There is no formal accountability mechanism that revisits defense strategy after a conviction. An appeal can challenge a denied instruction, but it cannot undo a report that was never written. The second legal annotation concerns what the cross-examination of Cupchek's own testimony likely accomplished for the prosecution. Salisbury's sentencing argument referenced Cupchek's testimony directly, noting that while Cupchek did not deny acting, he also did not admit to all the physical aspects of what occurred. Under Ohio law, ethnic intimidation under Revised Code 2927.12 requires the state to prove the underlying offense, here assault and abduction, was committed because of the race, color, religion, or national origin of the victim. That specific element, the why behind the conduct, is what separates ethnic intimidation from a standalone assault charge. Most people believe that if a defendant takes the stand and admits to physical contact, that admission alone proves the case. That is not what the law requires. The prosecution still had to prove the motive element beyond a reasonable doubt, and Cupchek's own testimony, by acknowledging conduct while minimizing its severity, gave the jury room to find both the conduct and the motive without needing additional witnesses. The prosecution's closing argument at sentencing rested on institutional weight. A Medina County jury, representing the community, heard all the evidence and convicted quickly. The victim suffered lasting physical and psychological harm. The defendant, even after conviction, had not fully reckoned with the scope of what he did. A prison sentence was not vindictive, the state argued. It was proportionate to a verdict the community itself had delivered. The defense's closing argument rested on the whole of a life. Donald Cupchek was a father, a coach, a police officer, a man surrounded by community members willing to vouch for his character in writing. He had already served 82 difficult days in jail. His risk of reoffending was assessed at the lowest possible score. Prison, the defense argued, was not necessary to protect the public from a man the evidence showed was unlikely to ever stand in this position again. The open question the judge had to resolve, that neither argument fully answered, how much weight should a court give to a defendant's character and low recidivism risk when the harm to a specific, identifiable victim was severe, ongoing, and rooted in a protected legal category like ethnic intimidation. The court imposed 18 months in prison on each of the 2/3 degree felony abduction counts, 10 months on the 5th degree felony ethnic intimidation count, and 120 days on the misdemeanor assault count, all to run concurrently. Mandatory post-release control would follow, between 1 and 3 years at the discretion of the Ohio Adult Parole Authority. The sentence was not the maximum available under Ohio law. It was also not the community control sanction the defense requested.
And the impact that had on the victim. And so after consideration of all the relevant factors set forth in the statute, and also the information contained in the pre-sentence investigation report, it is the sentence of this court that on count 1, a felony of the 3rd degree, you will have 18 months in prison. On count 2, also a felony of the 3rd degree, you will have 18 months in prison. On count 3, a felony of the 5th degree, you will have 10 months in prison. And on the misdemeanor of the 1st degree, you will have 120 days in jail. Your time will...
This sentence reflects the core principle underlying Ohio Revised Code 2929.1 and 2929.1 that a court must balance the seriousness of an offense, including statutorily defined aggravating factors like the protected class motive required for ethnic intimidation against an offender's individual circumstances. The judge's explicit statement that the focus was on behavior and victim impact rather than character alone reflects the same principle articulated in countless American sentencing proceedings, that good character does not erase accountability for documented harm to another person. This balancing test echoes the reasoning the United States Supreme Court applied in Kuhn v. United States 518 U.S. 81's 1996, which confirmed that sentencing judges retain broad discretion to weigh offender characteristics against the specific harm caused rather than applying a one-size-fits-all formula divorced from the facts of the individual victim's experience. A jury verdict is not the end of accountability in the American justice system. It is the beginning of a second, equally consequential decision about what that verdict should cost. Every American who has ever believed character alone should excuse conduct watch that argument fail in a Medina County courtroom today. The law does not ask whether you are a good person. It asks what you did to someone else and what that conduct deserves. The next video examines a case where a denied jury instruction became the entire basis of an appeal and the legal standard courts use to decide whether that kind of trial error requires a new trial entirely. Was the absence of a justification instruction and an expert report at trial a strategic failure by the defense that materially changed this outcome, or was the jury's verdict so clearly supported by the evidence that no instruction or expert testimony would have changed the result? And if it was a strategic failure, should a defendant be able to seek relief for his own attorney's preparation gaps after conviction?